Swayam Prabha. Digital India. Educated India.
Hello students, continuing our discussion on the jurisprudence and the Indian legal system. We are now on lecture number 17, which will deal with the judicial precedent as the source of law. We have been discussing about the sources of law, the different sources of law, what is the meaning of the source of law, what is the importance of source of law, and we have also discussed about two different sources of law. The first was custom and the second was legislation. Now, this is the third source of law, which is called judicial precedents. Judicial precedents are very important. How precedents can be made, we will also come on to that question. Whether any judgment, you must be knowing that judgments can be also called judicial precedents. But the question is that whether all the judgments can be called judicial precedents. The answer will depend upon several factors. Why not we should try to understand whether all the judgments must be considered as a judicial precedent or not. Whether we should be able to answer this question, that depends on the knowledge that what are the things which are required. Now, the first thing that is required is that there must be the existence of the courts. The whole judicial precedent system will not work if there will be no institutions, the dispute resolution institutions, and these dispute resolution institutions are called courts. The formal, this is the formal system of dispute resolution, and this is called the courts. Although there are tribunals also, but the judicial precedent will be applicable on the tribunals separately, that we will deal with later on. But the first thing is there has to be the whole system of the courts. Then the second is hierarchy of courts. There must be some arrangement of the system of the court. At one place there will be one court, and at the other level there will be another court. So, we will also see about the hierarchy of courts today. And the third thing is that even if there are the courts and there is the hierarchy amongst the courts, but if there is no authority of the judgment of the courts, then this will not be a precedent. So, what is the meaning of authority? Authority means legal authority, and whether it is binding on the other courts or not, on the subordinate courts or not, on the lower courts or not. So, unless and until there is the authority of the judgment of the court, there cannot be the system of judicial precedents. So, the third thing which is important to make a judgment a judicial precedent is the authority. Then even if there are the courts, even if there is a hierarchy of the courts, even if there is authority of the judgment of the court, but if there is no originality in the judgment, if there is nothing new in the judgment, if there is no principle, new principle has been laid down, then this will not become a judicial precedent. So, there should be some novelty, there should be something new which should be there in the judgment. If the judgment contains the old thing, if the judgment just adheres to the old line of thought, if the judgment is simply a reiteration of the judgment of the earlier cases, then this may not be considered as a judicial precedent. The fourth is the originality of the judgment And then the fifth is, which is also very important, that the judgment must be reported. If the judgment is not reported, then even when the judgment is a kind of very important judgment, but then reporting mechanism must also be there. And it is also the power of the court at the time of delivering the judgment to say that this judgment, whether it is reportable or not. All the judgments may not be reportable. So, first of all, the judges at the time of delivery of judgment will say that this judgment is reportable. And if they say that, then this reportable judgment may be reported by the different places and by the different publishers and the reporting journals. So, once it is reported, only then there will be a precedent. Because why this reporting is important, that is also important to understand. The reporting is important because the court has delivered the judgment. If it is not known to the people at large, then how will this will be available, how the people will come to know that this is the ruling of the court, this is the precedent which has been made by the court, and therefore the reporting of judgment is also a sine qua non to make a judgment a judicial precedent. So, all these factors are important. Normally we understand that judicial precedents are all the judgments of the Supreme Court or the High Courts, but now you must have understood that it is not the fact that all the judgments will become the judicial precedent. Judicial precedents are kind of a separate class of judgments from the ordinary class of judgments, and unless and until all these factors, all these important elements of a judgment are not fulfilled, there will be no creation of the judicial precedent. So, the first thing that we saw, that there is the importance of the courts, and the second thing that we saw was there must be hierarchy of the courts. Let us try to understand the hierarchy of courts in our own country. If there is a hierarchy of courts in our own country, the system of judicial precedent will definitely be working smoothly. Let us see that what are the provisions relating to the hierarchy of courts in our constitution, and then we will move on to see the courts itself. Entry 11A in the third list, list 3, which is concurrent list, provides about the administration of justice. Earlier this was in the state list, but now administration of justice is in the concurrent list. And as we all know that our legal system is a unified judicial system. So, from the bottom of the courts, the top court are all linked, they are all unified, and only then this system of judicial precedent that will work. So, at the top is the Supreme Court, and then there are the high courts in the different states, and the high courts are also the appellate courts, and the Supreme Court is the appellate court also, which is the highest court. And below the high court there is a network of subordinate civil and criminal courts in each state. The organization and the composition of the Supreme Court and high courts is also given in the constitution. The subordinate or the lower courts is organized under the statutes of the individual states. However, certain provisions were incorporated in the constitution with a view to ensure the independence of the judges. So, this is the kind of hierarchy which is given in the constitution and also in the criminal procedure code, and now we have the BNSS that also talks about the hierarchy of courts. We will also deal with all these things. First of all, we will try to understand about the jurisdiction of the court which is at the apex, which is called the Supreme Court of our country. The jurisdiction of Supreme Court, it is having different types of jurisdiction. The Supreme Court is entrusted with large number of powers, which is having original jurisdiction as well as appellate jurisdiction. It has also revisional jurisdiction, and also it has advisory jurisdiction, and then it has the writ jurisdiction also. So, this court is having all the kinds of jurisdiction which are possible, and the Supreme Court is therefore is the court which is having the highest powers. Now, we will see that the original jurisdiction of the Supreme Court, how and where it is laid down. You see that original jurisdiction of the Supreme Court, it is also interesting to understand the jurisdiction, original jurisdiction, since the time when the Britishers, they had established the Supreme Court. Before the Supreme Court, what we see, the Supreme Court now was called the Federal Court when the Britishers were there, and what we call now the High Courts. Before these High Courts, there were Supreme Court, 3 Supreme Courts in place of those 3 High Courts. So, those High Courts are called the Chartered High Courts. We will come also to those Chartered High Courts and the difference between the Chartered High Courts and the non-Chartered High Courts in some time. But what I am telling you, that the Supreme Court of now is having the original jurisdiction, because those original Supreme Court, 3 Supreme Court, they were also having the original jurisdiction. Original jurisdiction means that the cases or matters which are referred to the respective court at the first instance. That means that a matter can directly go to the Supreme Court if that pertains to the original jurisdiction of that court. So, in our country, there may be chances of disputes between the center and the states, which may concern certain provisions of the Constitution, and in that case the Supreme Court can be the court of the first instance. The states, they can directly go to the Supreme Court. So, the original jurisdiction lies when there is a dispute between the states and amongst the states. If there is a dispute between the states, who will resolve it? The Supreme Court is there. Article 131 of the Constitution points at the original jurisdiction of the Supreme Court. So, it says that if there is a dispute between the central government and the state government, at that time also the dispute may be resolved by the Supreme Court. So, this possibility was also foreseen, and therefore, the Supreme Court was given original jurisdiction in this matter. Disputes and controversies between state governments in the country. So, I told you that if the states are having disputes, where will they go? They will also go to the Supreme Court in the first instance. They should not go to the High Court in the first instance, rather they will have to go to the Supreme Court in the first instance. Maybe that Government of India on one side and the states on the other side, and one or more other states on the other side, that may also happen. Suppose Government of India is A and 2 states B, C, they also join together against the Government of India. Then the Government of India may be there versus A, B states may be also there. So, this is also the possibility, different states joining together versus the Government of India. But who will be the court? The court will be the Supreme Court. The court of the first instance court is the Supreme Court, and therefore, this is called the original jurisdiction. Then we will come on to the appellate jurisdiction. What is the appellate jurisdiction? Appellate jurisdiction means that the jurisdiction of the court, that side of the court where appeals are heard. So, you all are aware that the provision of appeal is there in the court system. So, if there is a order or the judgment of the district court or the subordinate judges, this might go in appeal to the other judges who are sitting at the higher level. So, in Supreme Court also, from the district court, the appeal might go to the High Court, and from the High Courts, appeal will go to the Supreme Court. So, this is provided in Article 132 and Article 134 capital A. The Supreme Court is primarily a court of appeal also and has been given the widest appellate jurisdiction, and Articles 132 to 136 of the Constitution deal with the appellate jurisdiction in the constitutional, civil and the criminal cases. So, all kinds of cases, the final jurisdiction, appellate jurisdiction will lie in the Supreme Court. As far as Article 132 is concerned, in the constitutional matters involving the interpretation of the Constitution, which may arise out of any proceedings which are there, whether civil or criminal or otherwise, which have been there in the High Court, from there can be appeals. This article provides that an appeal will lie to the Supreme Court from any judgment, decree, final order of the High Court, if the High Court certifies that the case involves a substantial question of law as to the interpretation of the Constitution. So, this certificate, if it is provided by the High Court itself, then also the possibility is that the appeal will be there in the Supreme Court. As far as civil matters are concerned, Article 133 is the relevant provision which confers a constitutional right to appeal to the Supreme Court in civil matters. This provides that apart from appeals by special leave, which is under Article 136 of the Constitution, appeals on constitutional grounds under Article 132 also, an appeal may lie to the Supreme Court from a civil proceeding before any High Court in the territory of India, if the subject of appeal is a judgment, decree or final order. The High Court grants a certificate for such an appeal that the case involves a substantial question of law of general importance, and in the opinion of the High Court, the said question needs to be decided by the Supreme Court. When all these criteria are fulfilled, then the Supreme Court can have jurisdiction in the civil matters also. In criminal matters, Article 134 is relevant, which says that an appeal lies to the Supreme Court against the judgment, final order or sentence in a criminal proceedings of a High Court. And it also says that on appeal, if there is a reversal of an order of acquittal of an accused person and by which he was sentenced to death, then also an appeal may lie. And like the earlier article, if the High Court certifies that the matter is fit and this one should go in appeal to the Supreme Court, then that will also be a situation when the Supreme Court will accept the appeal. There is also a very interesting provision which is called Article 136 SLP, special leave petition, special leave to appeal, and therefore, this provision confers an overriding jurisdiction and it gives extensive powers to the Supreme Court to grant special leave to appeal from any judgment, decree, determination, sentence or order in any cause or matter which is passed or made by any court or tribunal in the territory of India. So, this is a very difficult, although, because normally what you do that you jump the queue, otherwise you would have to go like in the queue you have to first of all go to the High Court and thereafter you can only go to the Supreme Court. But if you want to jump the queue, if you want to go from within the High Court, suppose if there is a appeal system from single bench to division bench and division bench to constitution bench or the full bench. So, this you can jump the queue, and what you can do that you can file your petition which is under Article 136 and you can go in appeal, and if the Supreme Court will accept, this will be a special leave from the other courts, special leave petition. This is called therefore a special leave, you leave the jurisdiction of one court, and therefore this is a special leave petition. There is also a review jurisdiction of the Supreme Court, and the review jurisdiction means that the Supreme Court shall have power to review any judgment pronounced or the order made by it. So, this is also, you may not understand this provision, but when I will discuss the doctrine of stare decisis, then you will understand the importance of this article, because the doctrine of stare decisis will be applicable. Why? Because it says that the Supreme Court can also review its judgment. And also the second thing is that the Supreme Court judges are also not infallible. They can also commit an error. They can also be doing something which sometimes they overlook a law. So, this may happen. Therefore, a system of review has to be there, and this system of review is possessed by the Supreme Court. We have also the writ jurisdiction, and the writ jurisdiction says that the Supreme Court can issue different writs. You may say that what is the meaning of writ? When I ask my students what is the meaning of writ, someone will say that it is a kind of written order, therefore it is called writ. But the writ is not just a written order. That is a order, that is a written order, but it is not simply a written order. This is a quick delivery of justice. This is an order by which there is a quicker delivery of justice, and especially this writ petition is filed when there is a violation of fundamental rights of any citizen. If the fundamental rights are violated, then a person can file a writ petition in the Supreme Court, and that writ petition can be heard at the first instance. There will be no delay in the hearing of the writ petition, and therefore writ petition are very important. The writ jurisdiction of the Supreme Court is very important, and as you all know that there are different writs which can be issued by the Supreme Court. For example, the writ of habeas corpus, the writ of certiorari, the writ of mandamus, the writ of quo warranto, the writ of prohibition, and any other writ in the nature of this kind of system. So, not only this, Article 139 further says that Parliament may by law enlarge the existing writ jurisdiction of the Supreme Court and confer on the Supreme Court power to issue directions, orders or writs for any purpose other than those mentioned in Article 32. So, for any other purpose, maybe for the enforcement of fundamental rights. So, you see that the writ jurisdiction of Supreme Court is very important, and the Parliament of the country has got the powers to enhance the writ jurisdiction of the Supreme Court. Finally, the Supreme Court possesses advisory jurisdiction. Under Article 143, if the President of the country is satisfied that a legal question needs to be asked, then in such case what can be done? It can take the advice, the legal advice from the Supreme Court, and the Supreme Court under Article 143 is bound to give the advice if the matter pertains to a legal question. If it is a political question, if the Supreme Court decides that no, the question was not legal question, in that case the Supreme Court may also say that I will not give you, we will not give you the advice, because the question must be a legal question. But the President has the power to ask for the advice, and this is called advisory jurisdiction of the Supreme Court. Once we have understood the jurisdiction of the Supreme Court, because that is important, and why we have discussed the Supreme Court, because Article 141 of the Constitution says that the judgment, the orders of the Supreme Court are binding on all the courts of the country, and therefore this is the system, this is the authority. Article 141 is the authority. I told you about the first of all, to make a judgment, a precedent, the first thing was court, the second thing was the hierarchy of courts, and the third thing was authority. Now, this authority is there in the judgment of the Supreme Court, which says that Article 141 says that the judgment of the Supreme Court is binding on all the lower courts, and therefore the High Court is the lower court compared to the Supreme Court, and the high courts are also having different types of jurisdiction. But before going on to the jurisdiction, we will also see that high courts of our country are basically of two types. One type of high court is called the chartered high court, and the other type of high courts are called non-chartered high courts. Now you might wonder, what is the difference between this chartered and non-chartered high courts? The answer is that the chartered high courts have a history since the British times. I told you in the last lecture that when the Britishers, they had established the Supreme Court and later they were converted into the High Court, at that moment of time what they had done, that they had established these Supreme Courts by way of the charter issued by the King of Britain. Now therefore they were called the chartered Supreme Courts, and later on they were called the chartered high courts, because they were the original high courts of the country, which were established by the charter of the then king. It means that there are very few chartered high courts in our country. The original chartered high courts have been, one is Calcutta, the other is Madras, and the third is Bombay High Court. But the fourth chartered, it was not originally chartered, but the similarity with the chartered high court has been given, and that is the Delhi High Court, because now this is also the capital, this is located in the capital of the country, and therefore the Delhi High Court is also given such status. But this is not original chartered high courts. There are other high courts which are called non-chartered high courts, and those non-chartered high courts, they do not have original jurisdiction, and therefore once we will discuss about the jurisdiction of high court, you will find that only some high courts have original jurisdiction, not other high courts have original jurisdiction. Let us see that what are the powers and what are the jurisdiction of the high courts. We have Article 215, which says that high courts are the courts of record, which means that this has the power to punish anyone for its contempt. So if anyone is not following the orders of the high court, then under Article 215 the high courts can give such kind of can proceed with the contempt proceedings, and the person may be punished. Likewise, high courts also enjoy, I told you about the original jurisdiction, high courts also enjoy the appellate jurisdiction, high court enjoys supervisory jurisdiction, high court enjoys writ jurisdiction, and high courts, they have also the power to interpret the constitution. So there are these kinds of powers, jurisdiction of the high courts. Let us see Article 227, which talks about the supervisory jurisdiction. I told you that supervisory jurisdiction means that high courts must have the power to supervise the lower courts. There may be hundreds of lower courts and under the jurisdiction of the high court. How can it supervise? Therefore, judicial as well as administrative side of the lower courts, they must be supervised, and Article 227 that talks about the supervisory jurisdiction. Further, writ jurisdiction, which is also very important. Article 226 of our constitution empowers the high court to issue the writ jurisdiction, and you will be astonished to know that the writ jurisdiction of high court is even larger. Why? Because it says that the power of the high courts is not simply limited to the issuance of only 5 types of writs, but other writs which may be in the nature of such writs. So the high courts have the power to issue the writ jurisdiction. Suppose someone's fundamental rights are violated, it will not be necessary to directly go to the Supreme Court, which is lying in the capital, national capital, but a person can directly go to the high court when the fundamental rights are violated. Then I told you that there will be original jurisdiction, Delhi, Calcutta, Bombay, Madras, and one more has been added, which is the Himachal, which have the original jurisdiction, and all other high courts, they exercise extraordinary original jurisdiction under Article 226. Then we have the appellate jurisdiction. The high courts are vested with appellate jurisdiction by statutes and by procedural codes, and therefore any appeal from the lower courts, that will also lie in the high court. Revisional jurisdiction. The high courts have the power to revise the judgments of the lower courts, and therefore the high courts enjoy this power, and this may sometimes amount to interference, because the justice was not delivered, and therefore revision is also important. Once we have understood about the high court jurisdiction, we will also try to understand about the subordinate judiciary. Let us try to understand the subordinate judiciary. Article 234 of our Constitution and Article 233 of our Constitution tell us about different provisions relating to subordinate judiciary. Article 233 talks about the appointment of district judges, and Article 234 talks about the recruitment of persons other than district judges to the judicial service. Then we have the judicial structure at the lower level, and the CPC laid down the framework for the system of courts in the country, and this is on the civil side. You might have heard that the judges are called the district judge and additional district judge, and also there are civil judges, and then the senior division judges and the junior division judges. On the criminal side, there are sessions judges, additional sessions judges, and the chief judicial magistrate and the judicial magistrates. So this is the kind of judicial structure at the lower level in our country. As far as the civil court of the district is concerned, the district court may have the power over the civil matters, and the civil court may also exercise appellate jurisdiction in those cases where even there are lower courts than that district court. So this may also be possible. As far as the civil judge senior division is concerned, there are the courts which are called senior division courts, where there will be senior division judges, and there will be junior division civil judges who will be having less pecuniary jurisdiction. So it depends upon the pecuniary jurisdiction of the court, that the court is the senior division court and the junior division, and likewise the judges. Now we have the Bharatiya Nagrik Suraksha Samhita BNSS, which also talks about the subordinate judiciary. Sections 6 to 20 of the Bharatiya Nagrik Suraksha Samhita BNSS talk about such things. Section 6 of this BNSS provides that there shall be in every state the following classes of criminal courts. The first will be court of session, the second will be judicial magistrates courts of the first class, and then the third will be judicial magistrate court of the second class, and the last will be the executive magistrates. Section 8 of the BNSS talks about the sessions court, and before going on to sessions court, I will tell you that why is it called sessions court? Does it run in some sessions? The answer is no. But then why this is called sessions court? Again, this has a history. During the British time, what happened, that the Britishers, they gave their judges the power to maintain law and order, and to maintain law and order, what they did, that they could try the criminals and those people who violated the law at the circuit houses. There were circuit houses in the district, and they could go to the circuit houses, and there they could have the court. They were called justices of peace, JPs. So those justices of peace, when they arrested the criminals in the circuit houses, and then in different sessions in different circuit houses. They were going around the district, and from there this sessions court system has evolved. Now the sessions court are established in the districts, and in the district all the cases, all kind of severe and grave cases, including culpable homicide, robbery, waging a war, these are all tried in the sessions court, and the sessions judge may pass any sentence authorized by a law, but only the sentence of death has to be confirmed by the High Court. The session judge has appellate jurisdiction also. He can hear appeals from the courts of judicial magistrates of the first class and also of the district magistrates. Any person convicted on the trial held by the sessions court may appeal to the High Court. Then there is also the CJM's court and the CMM's court. Section 10 of the BNSS provides for the appointment of CJM court. The CJM shall be subordinate to the sessions judge. The appointment of CJM is made by the High Court of the state concerned from amongst the judicial magistrate first class. The High Court can also appoint from amongst the magistrates of the first class an additional chief judicial magistrate. So there is a possibility now of appointment of additional chief judicial magistrate also. Once we have understood the courts from the top to the bottom, from the Supreme Court to the district courts, now is the time to just know about the tribunals. Tribunals are also established, the commissions are also established, special courts or special tribunals, they are there to provide effective and speedy justice. And in the tribunals you will find the people who may have expertise in the matters. These tribunals have been set up in India because there has been a lot of pendency of the matters in the various courts, and these tribunals are not bound by the Civil Procedure Code or by the Indian Evidence Act, but they have to follow the principles of natural justice. And we can have some examples of these tribunals like National Company Law Tribunal, like Central Administrative Tribunal, like Income Tax Appellate Tribunal, like Railway Claims Tribunal and Competition Commission. So we have now seen the hierarchy of courts in the country. So what we have seen, that there must be the courts, there must be hierarchy of courts, there must be authority of the courts, and thereafter we say that the judgment. What is the judgment? Now if all these things are fulfilled, then we have to say that the judgment must be having some new principle laid down, some new novelty has been laid down, and when that is done, then only we can say that the judgment is a judicial precedent, one of its kind, judicial precedent. And if that happens, then there may be certain factors which may increase the authority of the precedent. And you know what, sometimes you might have heard that there is a single judge bench, there is a division bench, there is a full bench. Do you know, this is also the hierarchy in the within the court, there is a hierarchy. Otherwise we have seen the Supreme Court, the High Court and the district courts, but within the court itself, I told you about the district court, how can an appeal from the subordinate court will go to the district court, and likewise within the High Court there is a possibility of appeal from the single judge to the division bench, and from the division bench to the full bench, from the full bench to the constitution bench, and thereafter it may go in appeal to the Supreme Court, and within Supreme Court the same system prevails, the single judge, division bench, the full bench, constitution bench, and then other full bench or the higher strength of judges. So what I was telling you, that there may be certain factors which may increase the authority of the precedents. Although precedents have the authority, but there may be some situations in which the authority can be increased. And how that will be done? You can see how many judges were there when the judgment was delivered, whether it was a full judge bench or whether it was a constitution bench. If there was a constitution bench, then what was the number, actual number, because the minimum number of judges required to constitute a constitution bench is 5. So, how many judges were there, whether 5 or more than 5. So, this will be also the question when you try to understand the authority, the increased authority of the President. Then eminence of judges. Who were the judges who were constituting the bench? Even in the full bench, if there are the judges who are not enjoying the eminence, then maybe that it will be not considered as important, having as much weight as those judgments where there are eminent judges who were there on the bench. Likewise, eminence of lawyers. Who were the lawyers who are arguing the case? If the lawyers are not eminent, then maybe that the judgment, the President may not be carrying that much of authority, although it has the authority, by law it has the authority, but sometimes the shine is also there, more shine is there when the eminence of the lawyers are also there. Then the citation of the judgment, how much the judgment is cited by the different persons and by the judiciary itself. If a judgment has not been cited, even if it was a precedent, it has not been cited, then it will not have increased authority. We are talking about increased authority, we are not talking about by law the authority which is given in law. And then if a judgment has been affirmed by the court, the different court, when suppose if the Keshwanand Bharati judgment is given and later on the judgment has been affirmed by the benches constituted at a subsequent date and time. So, then this will also increase the authority. If the judgment is a unanimous one, all the judges they gave the verdict, there is no difference of opinion, you see that the authority of the judgment will again increase, the precedent, the value of the precedent will further increase, because all the judges were unanimous, they all decided in one vein. And when a judgment is passed and subsequently a law is passed by the parliament and that law incorporates the judicial precedent, that also increases the authority of the judicial precedent, that also increases the weight of the judgments. So, these are some of the factors which increase the authority of precedent. Likewise, we will see that what are the factors which decrease the authority of precedent or sometimes destroy the authority of precedent. When the higher courts reverse the judgment of the lower court, or I was talking about the letters patent system where you can go from the single judge bench to the division bench, you will also find there that suppose if a single judge bench has given the order and the division bench has overruled or reversed, in that case the whole value of precedent will be destroyed. Sometimes a judgment is delivered in ignorance of a relevant statute. Now, if that will be the case, it will not be a good precedent, and maybe that in very short span of time the precedent's value will be diminished. Some of the judicial precedents are also called sub silentio, means that all the points which should have been argued were not argued, and therefore the judge was not aware of the different angles of the case, the different relevant laws which might have been applicable in the case, and therefore this judgment, this precedent will also be not carrying that much weight as it would have carried if there will be all the things which were argued and then the decision was given. And further, if the decision is divided, suppose if there is a constitution bench of 5 judges and it is the final judgment is 3-2, means 3 in support and 2 not in support of a judgment. Now, in that case this will be a kind of a very tricky situation. Although this is a precedent and this is a majority judgment, but maybe that this will not carry as much weight as a judgment in which all the judges were unanimously delivering the verdict. So, we can see that within the precedent system there are different things that also should be understood, so as to make the precedent as very important source of law. I told you earlier about the doctrine of stare decisis when I was talking about the powers of revision of the Supreme Court and the High Courts. I told you that these are the powers which are given to these high courts only. Otherwise, what will happen, that if every judgment would be reversed, or if every judgment would be again reviewed, then this will be creating not a very good situation. Therefore, the doctrine of stare decisis has been also given and accepted in our country, which means that stand by your decision. The full form of stare decisis is a stare decisis et non quaeta movere, means you stand by your decisions and do not disturb the settled matters. So, normally the Supreme Court and the High Courts, when they deliver the judgment, they do not deviate from their own judgments. If you have taken a stand, if you have given the verdict, then you should take the stand that yes, this was the right decision. But if there is a miscarriage of justice, if there has been not a good judgment, that a judge considers that this was not a judgment which will carry weight, in such case it can be revised. Or suppose if miscarriage of justice has been there, then also it can be revised. But normally the doctrine of stare decisis, that is very important, and the Supreme Court and the High Courts, they all follow this doctrine. And I told you about this article 141, which recognizes the doctrine of stare decisis. So, we must also understand another component of the judicial precedent, that the stare decisis doctrine is also followed in our country, and this doctrine of stare decisis is followed when there is the doctrine of judicial precedent. Now, we will also look at the different kinds of precedents. There are two basic kinds of precedents. One is called the authoritative precedents and the other is called the persuasive precedents. Now, what is the meaning of authoritative precedents? Authoritative precedents mean that it will be binding. There is no if and but. The judgment which is given by the higher court, that will be binding upon the lower court. So, suppose if the full judge bench has given a judgment, then the division bench has to follow that judgment, and if the division bench has given a judgment, the single judge bench has to follow the judgment. This is called authoritative precedent. And if the High Court has given judgment, the district courts are bound to follow that. If the Supreme Court has given a judgment, the High Courts and the district courts are bound to follow that. This is called authoritative precedents. But there are also precedents which are called persuasive precedents. Now, persuasive precedents are called persuasive because it does not carry authority. It only persuades the courts to follow a judgment, although the judgment may be binding in other jurisdiction, but that judgment is not binding in that jurisdiction where the person argues the case and points out that, your lordship, please try to understand this judgment. This judgment carries significance. This judgment has lot of merits, even if it is not authoritative, even if it is not binding on this court, but still considering the merits of this judgment, the court should accept it and it should be given that authority. So, persuasive judgments you will have to persuade. And what are those kinds of judgments? For example, the courts of coordinate jurisdiction. For example, if the High Court of Delhi has given a judgment, then that judgment can be cited in the High Court of Allahabad High Court, but what will happen that Allahabad High Court judges, they will not be bound to follow the judgment of Delhi High Court, because the Delhi High Court is also High Court and the Allahabad High Court is also having the same kind of jurisdiction, equal jurisdiction. So the courts having the similar jurisdiction, they are not bound to follow each other's judgment, right. So that is called persuasive judgment. And therefore, suppose for example, the judgment of International Court of Justice, what will happen to the judgment of International Court of Justice? Whether this will be authoritative precedent for our Supreme Court or for our High Courts or even for our district courts? The answer is that our Constitution has not provided for this kind of authority of the judgment of the International Court of Justice. So this will be again persuasive, even if the judgment has come from International Court of Justice, but there is no linkage with the Supreme Court, and therefore unless and until the Supreme Court will not incorporate that the judgment of ICJ, that will not be carrying authority in the courts of our country. So persuasive judgments, persuasive precedents and authoritative precedents are also to be understood. When we understand the whole system of precedents, then we can also understand that whether the precedent that I am citing, whether this precedent is a persuasive precedent or an authoritative precedent. So if the precedent you find is the authoritative precedent, then it will be easy for you, because authoritative precedents will be binding upon the courts where you argue. But persuasive precedents are not binding, and therefore you can say that even if you find that judgment of coordinate jurisdiction court, then this will not be that much helpful unless you have again the ability to convince the court that, look, your lordship, this merits attention, this judgment merits attention of this court also, because the situations are similar. Then we will also try to understand the further two classification of the judicial precedents. Even if there is a judicial precedent, what we will say that a judgment may be running into thousands of pages. Sometimes a judgment may be going to 50 pages, 100 pages, and sometimes it may go up to thousands of pages. Now in that case, how will you decide that which part of the judgment is the judicial precedent? Now can you say that each and every word of the judgment becomes the judicial precedent? The answer is no, because there is also a formula. What is that? You will have to take out the ratio of the judgment, what we call ratio decidendi of the judgment. What is this? What is the meaning of the term ratio decidendi? Ratio decidendi means that the decision, the ratio of the decision. Decidendi means decision, and ratio, the ratio of the decision. Now what is the meaning of ratio? Ratio means that you divide. For example, if I say what is the ratio of 10 and 5, you will say 2. So this is how the ratio, what is the ratio of the decision? Likewise, we have to look at that which portion of the judgment out of suppose 500 pages or 600 pages or thousands of pages, we have to look at those portions of the judgment which carries very important points. What are those points that we must know? Ratio decidendi means what? Ratio, how to know the ratio? The ratio means the whole judgment. In the whole judgment, what you have to do? You have to find out the material facts, those facts which are material facts, and there is a linkage between the judgment and those facts. Maybe that the court has given lot of paragraphs and different thousands of words which have been used, but the facts you have to locate. Where are the material facts, and not all the facts. Maybe that in a judgment the court will find out that a person who is going to be punished may be having this dress, that kind of hair, that style of walking, but all these things may not be relevant to make a ratio decidendi. So, ratio decidendi is that portion of the judgment which talks about the material facts and the reasons of the judgment. Why on those material facts the judgment was delivered in this way or in that way. So, the reasons of the judgment coupled with the material facts, that is called the ratio decidendi, and the judicial precedent is what? Is the ratio decidendi, not the other portions. So, maybe that if you look at, if you read thousands of pages, maybe that only 50 pages will be relevant for the ratio decidendi, and only 50 pages or maybe even less than that, that will be relevant for making it the judicial precedent. The other part of judgment may be obiter. Sometimes a judgment is like when the judges talk to each other, and sometimes they also put it in the judgment. Sometimes argument had been put by the lawyer, and sometimes that was not meriting attention of the court, but sometimes those comments made by the judges, some of the remarks which have been made by the lawyers, they sometimes find a place in the judgment, but these are not the ratio of the case. This is called obiter of the case. So, as a student of law, when you have to understand the sources of law, what you have to understand that judicial precedent is also a source of law, but within the judicial precedents there are several other things that you must understand. And I told you that the judicial precedents, when we talk of judicial precedents, there are several things, like there must be, you must know the different courts of the country, you must know about the whole authority of the different courts, you must know about the hierarchy of the courts, and you have to also know that what new thing has been laid down, what is the new principle which has been laid down, and thereafter you have to look at the reporting. I could not tell you about reporting. The reporting is also very important, because suppose if the judgment, where will you find the reports? So, you might have heard about All India Reporters. This is a journal which publishes the judgments, the reportable judgments, and you should sometimes look at the All India Reporter journal, that is also available online. You can also have a look there, you will find the judgments which are reported. We have also the Supreme Court cases, SCC, and the electronic version is called SCC Online. That is also a good place where you can find the reported judgments of the different courts of our country. And likewise, there are several other softwares which are also reporting the judgments on a regular basis. You might have heard about India Kanun, and that Indian Kanun is also a very good place where the judgments are reported. So, this reporting is very important, and you must also try to understand that a judicial precedent, how many times it has been reported, how many times it has been cited, and then how to understand the ratio decidendi, the obiter dicta, how to understand the increased authority of the precedents, how to understand the decreased authority of the precedent, and we have also to understand that in the same court there is a system of internal appeal, and this is how the whole hierarchy within the system works. So, what we have seen, that this judicial precedent system is very well working in our country, and even the tribunals are bound by the judicial precedent. Suppose if the appeal will go from Competition Commission to the Supreme Court, then the Supreme Court judgment will be binding on the Competition Commission also. So, the tribunals are also bound by the judgment of the Supreme Court, and therefore, what we have seen, that the judicial precedents are an important source of law. I hope that you must have understood the different facets of judicial precedent as a source of law. Thank you for your kind attention.